telling you as eloquently as they should be able to, what they want, and they start, speaking in adult words, and it's pretty obvious sometimes.
Right away, right when they walk in. And so my first question usually is, and I'm not kidding, do you like Justin Bieber? And why? And so I try to change the subject very quickly, get them off the speech that they've tried to give. So, and then I try to find out why people like Justin Bieber. So I haven't discovered.
So when the child says yes, he reminds me of my dad, then you'll know that the lawyer went to the seminar.
In my case, if they say they like Justin Bieber, I put them in detention until they change their mind.
I say you will listen to Springsteen for 24 hours, and then we'll make a decision. But they don't do that.
I kind of got the sense that most of the time, if you do speak to a child, you prefer that it would be in an in-camera setting. It's only in the exceptional circumstance that you would have the child actually testify and be examined and cross-examined. Is that right?
Going back to one of your questions, I think it was asked, what is the impact on a parent as far as getting custody when the parent seems to insist that the child testify? And I had one case in particular where the guardian ad litem was on the fence, but because this one particular parent was adamantly insisting that the child get on the stand and be testify and be put under direct examination and cross-examination, said that spoke to him volumes about that parent's parenting abilities, and recommended custody to the other parent primarily for that reason.
A lot of people ask questions about experts and custody evaluations. And so, given the cost of custody evaluations, how useful do you find them in general? And I know there are going to be exceptions on either side, but given what the cost is, do you generally find custody evaluations helpful to your process, or are they just surplusage?
Can I take that one first? Not very useful at all.
Yeah.
All psychologists leave the room. No.
It depends on who does it. And I think there was a reference made to some psychologists this morning by Dr. Stolberg who do a great job. And what they do is they get everybody in the room, they talk about what they've done, the research they've done, and tell the parents their recommendations. And then oftentimes that settles the matter, because if they're good at it, and there are a couple that are. But my introduction as a judge to expert testimony was this. An art therapist, play therapist came in to testify. You'll love this. And she said, what I did is I brought the child into my office, and I have a sandbox in my office. I was picturing that to begin with. And she said, and I let her play with dinosaurs. And there was a brontosaurus and a tyrannosaurus. And the brontosaurus would get attacked by the tyrannosaurus, and they'd fight, and the tyrannosaurus would kill the brontosaurus would die, and then come back to life. And occasionally the brontosaurus gets stuck in a tar pit. And they said, after doing all that, playing that, the therapist said, that to me evinces that the child feels stuck and she's in the middle of a conflict. And I said, no, they're playing a game, and the dinosaur has to come back to life for the game to continue. Because my kids were doing it. I'm thinking, if that's true, then my children are really conflicted and stuck. I don't know. But so I have some skepticism about that. But if a good custody evaluation can work wonders. I think people around Richmond know the ones that do them well, and they can be helpful, and they can settle cases very easily.
I've had good success with them too. I find them some very, very professionals. But again, it's like everything else. It's one person's opinion sometimes, and you have to understand that even an evaluator comes at life with their own biases as to how the world should work. But it does help settle a lot of cases, because I think when they're jointly agreed, the people themselves often want to get to the right response, the right answer, and they may entrust that psychologist to make that decision for them. But then you see situations where the person doesn't get the right result, and they say, okay, now we just go litigate. In other words, I'll take the opinion if it's in my favor. If it's not, then we just litigate.
Are there any psychologists here from the Tidewater area? All right, then I'll stick with not very useful at all.
Is that your final answer?
Yes.
Interesting, because this is directly related to a presentation this morning. Somebody asks, how much credibility do you give an expert in a custody case that has not met with any of the parties or the children, but is simply testifying from a review of existing records?
I don't think I've ever had that. If I did, I'd say, why are you here? I don't know what they could offer. What?
I agree.
Okay.
Well, but I think that, just like this morning's presentation, if you could expose the fact that there was bias or there was suggestibility, I'd certainly listen to it, because, one thing about expert testimony is that it's designed to educate you about a topic that you're not familiar with. And so if there really was a good expert who said, look, this whole process of the CPS investigation, this was all highly suggestible, and they're trying to use all this, and I want to show you why. I don't need to meet with the child to tell you that, but they didn't follow the protocol. I think that would be extremely helpful, in my view, but it just depends on the circumstances. Because I think that's really the bottom line, is the process that these experts use to get to their conclusions. And a lot of us just don't know a lot about psychology or MMPI. We hear these terms, but we don't know. And I've seen good effective cross-examination that the wrong tools were used. That, isn't it suggested you don't use this on a child? Yes, they have to minimum cross-examination, yet you used it. And to try to show that they've used the wrong psychological tools. So I think it could be helpful in the right case.
I have also a problem with children in counseling because their parents are split up and there's some trauma related and they're having some problems, and they're in counseling and go to the custody hearing, and their counselor is there, summoned with the records, and to talk about what the kids say in counseling. Now I realize, and that it seems to me so violative of their rights and their privacy, and it's disruptive of the whole therapeutic process. But it's done. And I don't like that all the time.
But that's an issue that I think comes up a lot, that I think attorneys need to be attuned to. 801, 401.1 of the code, talks about the concept of expert testimony, but it does not guarantee the underlying admissibility of the hearsay that led to the opinion. And yet, I find that historically in cases, attorneys generally don't object and just let it all in, and you let the expert then get on the stand and say, here's what she told me, as opposed to just giving their opinions without being cross-examined about or direct examined about what the facts were that led to it, because a lot of it's just rank hearsay. So a proper objection can be made. The court can direct that we listen to the underlying facts, and on cross-examination under the statute, you can try to elicit what the basis for the opinion is. But it doesn't guarantee the admissibility on direct, and that's where I see a lot of hearsay coming in expert situations. In any event,
I'm not against all experts, but I will say that for a lot of them, they just as well stayed at a Holiday Inn Express last night. As far as their
You have issues, don't you?
I do. In fact, I'm seeing a psychologist right now about those.
And I'm going to subpoena those records.
But not in the Tidewater area. No. How often do you see what you would describe as active parental alienation? What do you do to combat it when you see it? And is the cure sometimes worse than the disease?
That's loaded.
There's such a spectrum of that. It could be subtle, it could be overt.
I can believe something. It depends on the level of parental alienation. If it's terrible, if it's just, if one parent is just doing everything in his or her power to alienate the other parent, sometimes the worst, the only thing you can do is to transfer custody. The problem with that is the child is absolutely convinced that the parent who is being spoken poorly of is just, they don't want to be with them. It's the last thing in the world they could ever imagine doing. It's almost like you're ripping their life apart because mom has done such a good job of demonizing, and I'll use the mom and dad situation instead of the other way around, but it happens both ways. But the mother has done such a wonderful job of demonizing the father that they are convinced that he's the devil incarnate. And to have to turn around to solve the problem by making the children live with dad is a horrible thing to do because the kids are just traumatized. But by the same token, if you determine that the father is a perfectly good father and there's absolutely nothing wrong with him other than the fact that the mother continues to denigrate him, that sometimes is the only remedy. And the kids recover. The kids spending enough time with dad, they get over the trauma and they realize that dad's not such a bad guy after all, and that mom was the one who created all these, created this whole illusion that dad is such a horrible parent. Don't like to do that, but sometimes that's the only solution.
Anybody else want to weigh in?
If it's not that bad, is you just essentially just read on the Riot Act and tell the parent that if it continues, that transfer of custody is a possibility. The other possibility is that they'll be held in contempt and sentenced to serve time in jail, possibly.
When I was young and stupid, which is not that long ago, and a new judge, I had parents in front of me both doing that. And I said, okay, I'm giving custody to the Department of Social Services. And the social worker came over to get him. And they had an epiphany. I did too. I don't know if I could actually do that, but I did it. But they had an epiphany, and all of a sudden they started being nice because they thought this guy's going to take our kids away from both of us. And I don't know how you do it. I don't know what you do with that. Could I have done that? Do you think that's legal?
Was that in juvenile court?
Yeah.
You can do anything in juvenile court.
That's funny. I had a lawyer when I was in juvenile court. Somebody made an objection to hearsay, and the lawyer looked at me and said, "The rules don't apply here, do they?" And I said, "Yeah, I think. I don't know."
Someone asked me one time, said, "Your Honor, if you refer to State Code section so-and-so," and I said, "What's the State Code?" I'm kidding. Okay. Is there a member of Jerk here? By the
And I'm looking around, I don't see any delegates.
Okay, that prompts a question too, because I have in custody cases where, and it happens where child they have a realization at 14 or 15 or 16 that they really don't have to do anything they don't want to do. They don't have to go see mom or dad, whoever's got visitation. They don't have to do it, and it's not because mom's telling them not to go or dad's telling them not to go. It's because they got other stuff to do, and they don't want to deal with dad. They don't want to deal with this nonsense. And so they say, "I'm not going to visit with my father." And so they come to court. Dad says she won't visit with me. Mom's saying, "I want her to go visit." The child's just not doing it. And they say, "Well, order her to go. Order the child to visit." I said, "No. But what do I do? She doesn't do it. Do I put her in detention? What do you do?" And I don't think. What do you do? You got any ideas?
Please write down the following code. The letter Z as in Zulu. Audio codes are embedded randomly throughout this program. Please write these codes down in the order in which they occur. The code again is Z as in Zulu.
I don't know.
I think you just tell them, look at the intact families where those 16-year-olds don't want to spend any time with their parents either. I mean, the same result would apply.
Well, see, that's what I tell them. They hit an age where they don't want to be with their parents. My youngest son was ignoring me at the swimming pool when he was 5th grade, 4th grade. He ignored me every time I came in there. I said, "Listen, dude, you ignore me again, I'm going to walk up in front of all your friends. I'm going to kiss you on the mouth in front of all of them. And we'll see how that happens." And I said it, and he knows I'm crazy enough I'll do it. But they don't want to be with their parents. At 15 or 16, then the parents don't. They think it's because mom or dad is saying, don't visit. It's because they don't want to be with you. You're an embarrassment, And so I get show causes of that all the time. Order them to visit with me. No, I can't do it.
The media tells us that negative campaign ads work. Our clients often want to go negative. They want to tell you why the other parent is the worst possible human being ever walking the face of the earth, as opposed to why they have a plan that would be best serving the interests of the children. Can you address how negativity affects your view of the parent whose attorney is advancing that? And do you have any words for counsel about going negative and whether or not that's the best strategy to take?
I think you have to look at the reason that the negativity is coming out. Is it purposely solely for the purpose of undercutting the other parent, or are they raising legitimate concerns? Sometimes negativity is necessary to point out significant flaws in the other parent's parenting ability, things that may be detrimental to the child. And if they don't bring those things up, I think they're sort of compelled to do so. So I think it depends on the circumstances. What is their motivation for the negativity?
To win the case. That's the motivation.
I understand, but are they bringing it up for a specific reason, or just for the sole purpose of making the other party look bad versus legitimate concerns? And sometimes you can tell Because if they start nitpicking, then it's obvious that the negativity is solely for the purpose of undermining the other parent. But if they raise a few, just a handful of very, very legitimate concerns, then I personally am not going to hold that negativity against them.
Well, I think it, again, depends on the
What a
facts. In the circuit
naive
court,
person.
the typical presentation, in my view, is a situation where there are other issues. For example, there is the divorce grounds itself. There is the equitable distribution, which has as a factor, factor 5, the circumstances and factors leading to dissolution. 2107.1 on the spousal support, where the court can consider the circumstances and factors. And so that evidence can come in even in a non-custodial context. You may be adjudicating custody as well, but you're going to hear about it probably in any event. I think a skilled practitioner, if they want to kind of take the high road, can try to compartmentalize their evidence and say, well, we're putting on our ED case first, and you're going to hear of it here, and you're going to hear the spousal support evidence over here, and then we get to custody, go through the factors, and maybe say, well, we're going to take a little more of the high road. But it's hard to do because there is pertinent negative evidence sometimes that's got to be considered. And sometimes it's venting, of course, and a lot of times it has nothing to do with your decision. Because ultimately, unless you're really going to take the unusual step of preventing a person from visiting, the parent is going to get access to the child, and it's probably not going to really make the difference between, Sunday night at 6 o'clock or Sunday night at 4 o'clock. I mean, where is it going? What are you going to really do with it? I mean, you have to kind of relate it to how you want it to impact the ultimate result. Telling the judge all the bad things he did during the marriage or she did during the marriage, where does that still leave you in terms of this parent's access to the child? Was it detrimental to the child, this conduct? Did the child even witness this conduct? And is it just something that has to be dealt with injunctively to say, stop doing it?
We're going a couple minutes over because Rich went a couple minutes short, so don't think I'm keeping you from lunch. I've been ordered to keep talking. So, maybe last question, maybe. To what extent do you use guardian ad litem in high conflict custody cases, and in what sense can the guardian be most helpful to you in those circumstances?
To what extent do we use guardians?
Well, see, in circuit court we don't automatically get them. I guess in a lot of JDR courts they automatically appoint them. But
well, I would say the greater the conflict, the greater the need for a guardian ad litem. And this is something that I at a previous seminar I made this point. I was in had a point counterpoint with one of my colleagues, believe it or not. But I think it's 16.1-266. I want to say F, I'm not mistaken, says that if both parties have counsel, then the court shall not appoint a guardian ad litem unless the court determines that the absence of a guardian would be detrimental to the child's best interest. My opinion is that both parties have counsel, the child's automatically in harm's way because.
Lawyers and psychologists.
No, well, and not because anything against lawyers, because I was one for 20 years, and I liked myself, so I guess I liked lawyers. But when you have parents who are represented by counsel, counsel has a singular purpose. That is to win for that parent, not to do what's in the best interest of the child, but to have a favorable ruling for that client, and that is their singular only purpose for being there. I didn't understand, perhaps, really the General Assembly's conclusion that when attorneys are involved, you necessarily don't need or probably don't need a guardian. I think the guardians are a very important part of the process. One thing that guardians has helped me with is giving me a lot of free afternoons because they are excellent at mediating cases and reaching settlements. If I don't have a guardian involved, chances are I'm going to have to have a hearing and have a contested hearing, and it's going to last 2-3 hours. If I have a guardian involved, a lot of the times
you can just do whatever the guardian tells you what to do,
and hand it to me right when the hearing's getting ready to start and say we worked this out. So I think guardians are incredibly valuable in the process, and I try to appoint them as often as I can. And I will say this too. I don't know about other localities. I'm not saying anything bad about other localities, but we've got some of the best guardian ad litems I think in the whole state. I've got a list of my top 10 that I would put on any case under any circumstances and be totally confident that they're going to do the absolute best job they could possibly do, and whatever recommendation they make is going to be right on point. So we are blessed with a wonderful.
Why show up, Judge Blow?
A group of attorneys who do that very challenging job for I would say very little compensation. They do it because they enjoy it, because they care about kids, because they're in it, for what they get out of it, in terms of feeling good, not for what they get out of it monetarily. So I think Guardians are wonderful. I think I said that, didn't I? I like Guardians.
So
They're obviously not psychologists. Anyway.
But
Thank you very much. Go ahead.
I was going to say, the problem, you appoint a guardian in juvenile court, and it's contested, and you make a ruling, and you rule in favor of one party or the other, and they come up to circuit court on appeal, and they say we want to reappoint the guardian. Well, the person that lost downstairs doesn't want the guardian reappointed, and so you get in a big tussle about we need somebody new because they're not fair. They're not. So that adds another layer.
But in the circuit court, typically there's not enough money. That's really the bottom line. I mean, when two counsel come to me and one makes a motion and say, well, all right, but we have to agree in advance who's going to pay for it. How is this person get paid? And typically in the circuit court, my experience has been, since the Supreme Court's not going to pay for it unless it's an appeal, there's just inadequate money, sadly, in most cases to justify it.
We have bake sales.
Yeah.
I would like to. Go ahead.
Before you clap for all three of us, I should probably disclose that Judge Rockwell's dog just growled at me.
Because you're a criminal.